FH and 23-21456-FH, People versus Matthew Eric Edward Smead. We are here today for a arraignment in this matter. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Pappan.
Good morning, Your Honor. Craig Pappan with the Attorney General's Office on case 23-21455-FH.
Rhonda Underwood for Mr. Smead this morning, Your Honor.
Okay, and Ms. Underwood, does Mr. Smead wish to have the information read?
We would waive the reading of the information, acknowledge receipt of its receipt and the witness list, Your Honor, request for discovery. We, at this time, would ask the court to enter a not guilty plea for Mr. Smead, Your Honor. And then I would just like to have a brief discussion on the issue of bond.
All right, I'll enter not guilty pleas for Mr. Smead in both of the cases, and we'll set a pretrial for about September 6th at 8:15.
Thank you, Your Honor.
Thank you, Your Honor.
September 5th, did you say?
6th.
Thank you.
All right, and go ahead. What is it you would like to say about the issue of bond?
Just that I talked to the Attorney General's office yesterday, and I know we were talking about some sort of lesser lump sum. Mr. Smead, I just talked to him. He has, I believe is it $400, Mr. Smead? Three that he could have filed with the friend of the court immediately, Your Honor. Mr. Smead has a number of medical issues that he needs to address, Your Honor, that he's very concerned about. I know that's not anywhere near 25%, but I feel it incumbent to ask if the bond could be reduced to that amount, and we can get Mr. Smead out and see if we can get some payments started, Your Honor.
Your Honor.
All right, yeah, go ahead, Mr. Pappan.
Yes, I would object on that. What we have right now currently is in excess of $13,000 in arrearage. He's charging normally at $266 a month. We haven't seen a payment in well over a year.
Can I ask a question?
What's your question?
What is the last job you guys currently have on file that I was paying out of?
I don't have that information. I don't know if Mr. Pappan has it or not. Ms. Underwood, what are Mr. Smead's medical issues?
Mr. Smead has COPD, Your Honor. He also has circulation issues. His medication is 2 hours away, and there is no one available to bring it to the jail, Your Honor.
And I can barely breathe sitting right here.
It may make it difficult for the prospect of employment and actually making any payments while he's out.
Honestly, I have a job waiting for me when I get out, and I can give you the name of the place of employment. And as soon as I get out, I can go there and start right away. And I will call the Attorney General's office and give them all information regarding my job. Payments would be no problem for me. If you guys were to release me today, I could make more than my monthly obligation payments. I would pay out of my pocket.
I would add, Your Honor, that if Your Honor were so inclined to do that, that he also be ordered to institute an income withholding order through the friend of the court immediately.
That would be no issue.
Who is the employer where you would be working?
It would be called Big Ray's Express Loop. It's on South Cedar Street in Lansing. And I would be able to get the address, phone number, and everything needed as soon as I was released.
All right, Ms. Underwood, how much did you say you had available to pay today?
300, Your Honor.
And I could have more money to the friend of the court by the end of the week.
All right, do think there is good cause to modify the bond from the statutorily required amount, in that Mr. Smead has medical issues which aren't being addressed at the jail right now, because he can't get his medication to the jail, and also because there is a prospect of receiving payments if he is released. I think that ultimately is the goal here. So I will modify the bond to be a $150 cash bond in each case, and add the requirement that Mr. Smead report an employer to friend of the court within 48 hours of being arrested, and that he work at that employer, set up an income withholding order with the friend of the court, and make regular payments while out on bond.
That would be no issue.
Mr. Smead, do you understand that
Yes, I
that
do.
$300 has to be paid today to the friend of the court directly?
Yes, I do understand that.
Thank you.
All right. We also need prints in both cases, so I'm going to sign an order for fingerprints.
Your Honor, I just want to clarify, because I think the instructions to the defendant was to pay the 300 to friend of the court, and I believe you ordered 150 in each of 2 files. I believe we only have 1 file with Mr. Smead. Is there a second file? Because that would not necessarily be to the friend of the court. I just wanted to clarify that.
So I've got 2 files. One is 23-21456-FH.
I see. Okay, very good.
And the other is 23-21455-FH.
Very good. I had the one cover sheet. Thank you, Your Honor.
Okay. All right, I think we're all set then with this case. So thank you for your time, Mr. Smead. You can let the officer that's with you know that you're done with court for today.
All right, thank you, Your Honor.
Thank you, Mr. Pappen.
Thank you now. Take care.
And Your Honor, since this is the first pretrial, your office will prepare the notice.
Yes,
Yes.
Thank you.
All right, we have Mr. Gerard here from MDOC. You're gonna need a breakout session with him.
Yes, thank you, Your Honor.
And then could you call the jail? Jeremy Carter. Oh, all right, Mr. Gerard, I'm going to place you in a breakout session with Ms. Underwood. If you give me just a moment.
Okay.
Kelly, judge will say first. Could we have Jeremy Carter on for the judge, please? Thank you.
Mr. Daly, do you need a breakout session with Mr. Carter?
No, Your Honor.
All right, we are on the record in file 19-19548-F8, People versus Jeremy Jamal Carter. We are here today for a pretrial hearing. As well as a pretrial on contempt of court for failure to appear on October 23rd, 2019. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
James Daly on behalf of the defendant.
All right, Mr. Daly, where do we stand with Mr. Carter's case today?
Your Honor, on both cases, we'll be pleading not guilty, asking for a trial. And if it's appropriate, I would like to ask the judge to this court to reconsider a bond at this time, but I don't know whether I can do that without setting it for a special hearing or not.
So how long do we need for a trial?
I think one day.
I think one day could do it, Your Honor.
All right.
I apologize, Your Honor. Could we do 2 days? I'm looking at Mr. Sneed's witness list, and there's maybe 12 to 13 witnesses potentially that Mr. Sneed could call. So I think 2 days would be safer.
Okay. Francis, if you're there, can you find us a 2-day criminal jury trial date, please?
Yeah, Judge. December 12th at 9 a.m. and Wednesday, December 13th, starting at 10:30.
Those dates are fine for me.
Works for the people, Your Honor.
Set a final pretrial then for December 6th. And Mr. Daly, what is it you would like to say about the issue of bond?
Your Honor, in this case, Mr. Carter when he found out that there was a warrant out for him on these underlying charges, he thought they had been dismissed. As soon as he was stopped by a law official, told that they had a warrant for him in Lenawee County, they let him go. And then he proceeded to drive down here on his own and turn himself in. He's fully employed. He has a job. He's been doing very well, and he has a meritorious defense to this case. We're planning on going to trial on that. And for him to sit in jail right now until December, he has a family he's supporting. He's working every day. He has a job that he can go back to now, and he's ready to go back to work and comply with everything. Since he's already turned himself in, and he believes that he has a meritorious defense to the underlying charge, that's why he thought it had been dismissed, because it's his belief that he wasn't involved in this. We'll have to let that work its way out at a jury trial. But to have him set in jail until December because of a mistake on somebody's part would be unfortunate for Mr. Carter.
All right, Mr. Bayanetto, you have any response to that?
I do, Your Honor. I actually had an opportunity to speak with Mr. Sneed about this yesterday. Mr. Sneed also prosecuted the co-defendant in this case. We would object to any modification of bond at this point. Mr. Carter does have a pending absconding charge that is in district court set for preliminary exam in September. Your Honor, I guess the problem that we have in this case is Mr. Carter has been gone for nearly 3 years. He does not live in the area. I think not having a cash bond in this case is we wouldn't be able to assure Mr. Carter's appearance. So given all those facts, I would ask that the court keep the bond that's currently set in place, and we can get this case wrapped up.
May I respond to that, Your Honor?
Go ahead, Mr. Daly.
Your Honor, I don't really disagree with anything that Mr. Bayanetto said, other than the fact this defendant turned himself in. If he waits until December, he's probably looking at more time in jail than he would receive if he's convicted of this charge. It was a false identity charge, and we are prepared to defend on that. And to have him set in jail on a property defense for 4 more months would really be a tragic outcome for this defendant.
So I'm sorry, what are you requesting in terms of the bond, Mr. Daly?
We would ask for a PR bond or a very small cash bond.
I'll take a tether.
I'm sorry, I didn't hear that, Mr. Carter.
I settle for a tether. An ankle monitor.
All right, so there's some difficulty here because of the length of time that the court went without contact with Mr. Carter. I do agree with Mr. Daly that looking at a trial date in December based on his charges, I don't know. Not charged with any habitual offender notices. Based on the charges, even if convicted, he'd be likely to serve less time than what he would serve waiting until the trial date in December. And given the fact that he has turned himself in, it supports the notion that this was an accident, or at least at some point he came back willingly and voluntarily. So I am going to modify his bond to a $1,000 cash or surety with a GPS tether. I think that gives Mr. Carter fair opportunity to be released, and it also puts some safeguards in place to make sure that he appears for his trial, which again will be December 2nd, 12th, and 13th, with the final pretrial on December 6th at 8:15. Court will issue a scheduling order.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor. May I speak to my attorney?
Mr. Carter, I'll get over to the jail and talk to you sometime today.
All right, thank you.
We'll get your bond set today. You have a $1,000 bond. I can arrange to have a bondsman come and post that for you if you want to.
Yes, sir.
Cost you $1. I'll get that done today.
All right, thank you.
Uh-huh.
You are a lifesaver, Mr. Daly. I will not
All
let
right.
you down. I will be the court every time you need.
Mr.
me.
Mr. Carter, I need the jail room for another person, so can you let the
Okay.
officer that's know that you're done with court?
Yes, sir. Yes, sir, Your Honor. Thank you.
Nicholas Blevins.
Yes, sir. Back him up. Oh, I need a deal.
Ms. Underwood, are you ready to proceed with Mr. Gerard?
We are, Your Honor. Thank you.
All right, so we are on the record in file 23-21385-FH, People versus Daniel Lee Gerard. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Bayoneto.
Ms. Bayoneto for the people.
Rhonda Underwood for Mr. Gerard in this matter.
All right, Ms. Underwood, where do we stand with Mr. Gerard's case today?
Your Honor, the offer in this case, Mr. Gerard is charged with assault on a prison employee, count 1, and count 2 is criminal sexual conduct in the 4th degree. The first is a 5-year felony. The second is a 2-year felony.
All right, I'm gonna have to mute Mr. Gerard's device because we're getting too much background noise from that device.
And the second is a 2-year felony with SORA requirements. The offer, as I understand it, in this case, is that Mr. Gerard complete to count 2, the criminal sexual conduct 4th degree, count 1, and the habituals will be dismissed. I've discussed that offer with Mr. Gerard, and he wishes to accept that offer today, I believe.
Mr. Gerard, I've sent a request to unmute that device at the facility that you are in. I don't know if there's someone there. You probably need to accept that or do something on your end to unmute that device.
Does that work then better?
All right. Yeah, thank you. Mr. Gerard, would you raise your right hand? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, sir.
You are Daniel Lee Gerard?
Yes, sir.
Mr. Gerard, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2, criminal sexual conduct, 4th degree?
Yes, sir.
Are you satisfied with Ms. Underwood and the advice that she's given you?
Yes, sir.
Do you understand that the maximum penalty for this offense is up to 2 years in prison?
Yes, sir.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with court. Is that correct, Mr. Bayoneto?
Correct, Your Honor.
Ms. Underwood?
That's correct, Your Honor.
Is that also your understanding, Mr. Gerard?
Yes, sir.
If a guilty plea is accepted, there'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and to have the witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, sir, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, sir.
And do you also understand that any appeal from the conviction and sentence pursuant to this plea would be by application for leave to appeal and not by right?
Yes, sir.
Do you understand that by entering the plea to this offense, you will be required to register under the Michigan Sex Offender Registration Act?
Yes, sir.
Do you have any questions about any of the rights that I have discussed with you?
No.
Do you understand that you're giving those rights up?
I mean, is this a sentence then?
No, this is a plea.
Oh, it's a plea?
Do you understand, Mr. Gerard, that you're giving up the rights that I've just reviewed with you?
Yeah, I understand.
You understand that if you're not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization?
Yes.
How do you wish to plead to the charge that on or about August 28, 2022 in Madison, 2022 in Madison Township, Lenawee County, Michigan, that you did commit the offense of fourth-degree criminal sexual conduct?
Guilty?
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Has anyone, do you understand that if I accept your plea, you will be giving up any and all claims that the plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter the plea?
Judge, you're a lawyer. Maybe when it's your turn, right, try to interrupt, but.
Yes, sir, I understand that.
Okay. Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Gerard to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Gerard, has your attorney promised you any particular sentence or estimated what your sentence would be?
What I know my sentence will be?
Has your attorney promised you any particular sentence or estimated what your sentence would be?
No, anybody told me what it would be.
I'm sorry, I wasn't able to understand what you said.
I said, no, ain't nobody tell me what it would be.
All right, is it your own choice to plead guilty?
Yeah.
Ms. Underwood, do you want to establish the factual basis?
Thank you, Your Honor. Mr. Gerard,
Yeah.
on August 28th, 2022, were you an inmate at the Gus Harrison facility in Madison Township, Lenawee County, Michigan, Lenawee County, state of Michigan?
I was an agent.
Okay. Thank you. And at that time, did you come into contact with a nurse at the facility?
Yes, I did.
And if I told you her name was Lisa Reynolds, I'm sorry, I'm sorry, I won't give that. But at that time, did you cop a feel of this person's buttocks,
Yes, I did.
and she did not give you permission to cop a feel of her buttocks, did she?
No, she didn't.
In fact, she made her displeasure about that known, correct?
She did what?
She, you did not have her permission,
No,
correct?
I didn't. Yeah, correct. I didn't.
Okay. Your Honor, I believe we've established the facts.
Mr. Bandito, do you have any questions?
No, Your Honor, I think that covers everything.
All right, I'll accept the plea. It's been given understandably, voluntarily, and accurately. Mr. Gerard's had full knowledge of his rights. He's had competent counsel. The court's not made any agreement regarding a plea or possible sentence in this case with the prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for September 22nd at 8:15 a.m. Mr. Gerard, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
All right.
Are you still at the Gus Harrison facility, Mr. Gerard, or are you somewhere else?
I'm still at, I'm at WCC.
All right. All right, thank you. Then you can let the officer that's with you know that you are done with court for today.
Okay.
I'm sorry, when was sentencing?
September 22nd.
September 22nd. Okay.
All right, thank you.
All right, thank you.
All right, Your Honor, are you guys gonna be taking prisoner Arrington next?
Yeah, if you have him available, we will.
Copy that. I'm gonna drop him off and grab him up.
Thank you very much. Okay, Mr. Glazer, you need a breakout session with Mr. Blevins.
Yes, I do, Your Honor, just for a second.
Ms. Underwood, you have Keegan Ferguson.
Yes, I do, Your Honor.
He is here. Do you need a breakout session with him?
I spoke with Mr. Ferguson. Do we still have the AG's office, Your Honor?
I do not. Is he a child support case?
I don't know. Mr. Pappen left. I'm not sure.
I don't know if he was aware of this one or not. Do you? All right, Mr. Ferguson, I'm going to place you back in the waiting room for a few minutes, unless Ms. Underwood, you need a breakout session with him.
Not at this point, Your Honor. I don't know, if Mr. McCrane is here, could she see if Mr. Pappen is logged into the other courtroom, maybe?
I will verify, Rhonda.
Mr. Ferguson, I'm going to place it back in the waiting room for a couple minutes.
Yes, Your Honor.
I have Mr. Pibbles here. Do you want to speak with him?
I've spoken with Mr. Pibbles, Your Honor.
Okay, give me a moment to bring him in from the waiting room.
Judge, Mr. Pappen is in Judge Anselon's court. I will let him know that we need him back when he is done.
Thank you very much. All right, we are on the record in file 23-50575-PP Beth A. Saudi versus Trevor L. Pibbles. This is date set for a pretrial hearing on alleged violation of personal protection order. We are proceeding today by video conference. Do we have someone from the prosecutor's office appearing on this one?
Yes, Your Honor, I apologize.
All right, Mr. Bayonetto, you want to place your appearance on the record?
Alex Bayonetto for the people.
Ron Dunwood for Mr. Pibbles, Your Honor.
All right, and Ms. Underwood, how does Mr. Pibbles wish to proceed with this case
I've
today?
spoken with Mr. Pibbles about this issue, Your Honor, and I believe Mr. Pibbles is going to accept responsibility and plead guilty to sending an email that he sent.
All right, so there's two allegations in the motion affidavit. One is the email, the other is driving past the petitioner. What are we doing with that allegation?
Mr. Pibbles?
Your Honor, I drove past.
All right, Ms. Fields, I don't want an explanation because I don't want you to say anything that might compromise your position if you don't want to plead to that. So, Ms. Underwood, do you need to speak to him about this?
Mr. Pibbles, are you going to plead to that?
I was talking on the phone. I wasn't filming her or anything.
But you did drive by.
It was my main route to work and home.
So maybe we should have a breakout, Your Honor.
1 second. All right, Mr. Glazier, are you ready to proceed with Mr. Blevins?
Yes, I am, Your Honor.
All right, we're on the record then in files 23-21355-FC and 23-21454-FH, People versus Nicholas Montgomery Blevins. The file ending in 454-FH is set for arraignment. The FC file is set for a pretrial hearing. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
John Glazier on behalf of Mr. Blevins, Your Honor.
And it should state for the record, we are proceeding today by video conference. Mr. Blevins is here by video conference from Lenawee County Jail. Mr. Glazier, where do we stand with Mr. Blevins' case today?
Your Honor, in regards to the safe breaking and the B&E file, he is going to plead guilty to count 2 with the understanding that count 1 and the habitual offender would be dismissed at the time of sentencing. The R&O file will waive the reading of the information, and that's to be dismissed as part of the plea as well.
Okay, Mr. Bayonetto, is that a complete and accurate statement of the plea agreement?
I missed the last thing Mr. Glazer said about the RNO file.
That file's supposed to be dismissed too.
Okay, yeah, that's correct. I was just making sure.
Your Honor, just for the record, I would indicate too that I sent a letter to have him screened on July 31st, and I know that Ms. Teskey was gone, so we haven't had that done yet, but we are having him screened for drug court.
Okay. Mr. Blevins, would you raise your right hand, please? You swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes,
And you are Nicholas Montgomery Blevins?
yes,
Mr. Blevins, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty today to count 2 in file 23-21355-FC, breaking and entering a building with intent?
yes, sir.
Are you satisfied with Mr. Glazer in the advice that he's given you?
Yes, sir.
Do you understand that the maximum penalty for that offense is 10 years in prison?
Yes, sir.
Neither prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Van?
That's correct, Your Honor.
Mr. Glazer?
That's correct, Your Honor.
Is that also your understanding, Mr. Blevins?
Yes, sir.
Plea is accepted. There'll be no trial. That means you'll be giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agreed, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, to have the witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at trial if you want to testify. You understand, Mr. Blevins, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial.
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you are not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization.
Yes,
Have any
sir.
questions about any of those rights?
No, sir.
And do you understand that you're giving those rights up?
Yes, sir.
How do you wish to plead to the charge that on or about January 12, 2023, in the city of Adrian, county of Lenawee, that you did commit the offense of breaking and entering a building with intent?
Guilty, sir.
Has anyone made any threats or promises to you to induce you to plead guilty to that charge?
No, sir.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea is given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your choice to enter the plea?
Yes, sir. My bad.
Is the prosecutor or defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Blevins to plead guilty?
No, Your Honor.
No, Your Honor.
Mr. Blevins, has your attorney promised you any particular sentence or estimated what your sentence would be?
No, sir.
Is it your own choice to plead guilty?
Yes, sir.
Mr. Glazer, do you want to establish the factual basis?
Yes, Mr. Blevins, back on January 12th of this year, 2023, you were here in Adrian and Lenawee County in the state of Michigan. Is that correct?
Yes, sir.
And at that time, you broke into a party store at 1551 West Maumee Street here in Adrian. Is that correct?
Yes, sir.
And when I say broke in, the business was closed and you forced your way in there. Is that true?
Yes, sir.
And it was your intent when you did that to steal something or commit a larceny from that building. Is that correct?
Yes, sir.
In fact, did you take something, lottery tickets or something like?
Yes, sir.
Okay. I don't have any other questions, Your Honor.
All right, Mr. Van.
I'm satisfied, Your Honor.
Has the court complied with MCR 6.302 B, C, and D, Mr. Bayonet?
It has, Your Honor.
Mr. Glazier?
Yes, Your Honor.
All right, I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Blevins has had full knowledge of his rights. He's had competent counsel. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for September 22nd at 8:15 a.m.
All right.
Mr. Blevins, someone from the probation department is going to be in touch with you to do a pre-sentence investigation interview. When you do that interview, please be truthful about this offense and about your background.
Okay,
They'll probably screen you for drug court at the same time.
okay,
It'll probably be Sarah Teskey.
okay.
All right. Thank you, Your Honor.
All right, bond we continued. Mr. Blevins, you can let the officer know that you are done with court for today.
Okay.
Your Honor, the only other one I have left with you is a Robert Lape. Is he on your docket?
He is, yes.
All right. He is in the hospital, Your Honor, having surgery today. He's been in the hospital since the violation was issued. I think it's for drinking. And the only reason I know he's in the hospital is his mother works with my wife, and Mr. Leap was in the hospital in Toledo while my niece was down there. My niece passed away, but at the same time, he's really banged up. And I expect once he's done with all his surgeries, he's going to go into a nursing home, I believe.
All right, Mr. Stevenson, are you there?
He's here. He'll be right here. Someone's talking to him. Judge, when's Blevins' sentencing date?
22nd.
September 22nd.
September 22nd?
It's my wife's birthday.
Okay. I'll tell Mr. Stevenson you're on.
Oh, okay.
Hold it for the judge, please. Thank you. Bye.
Okay, Mr. Stevenson, so Mr. Glazier has indicated Mr. Lake is in the hospital having surgery today.
Yes,
And-
I've been in contact with Mr. Lape. He's here locally in Adrian. So
Okay.
that's my understanding. And I spoke with him at the facility he's at.
All right, it sounds like we should probably just adjourn this out about a month and see where things stand. Does that seem
That'd be
reasonable?
fine, Your Honor.
All right. So let's set it for September 13th at 8:15.
All righty. Thank you, Your Honor. That's all I have with you this morning.
Okay, thank you, Mr. Glazier.
All right, we'll see you later.
Ms. Underwood, are you ready to proceed with Mr. Pibbles?
I'm sorry. Yes, Your Honor.
All right, so we're back on the record in file 23-50575-PP, Beth Saudi versus Trevor Pibbles. We're proceeding today again by video conference. Ms. Underwood, where do we stand with Mr. Pibbles' case now that you had a chance to talk to him?
Your Honor, as I stated, Mr. Pibbles will plead guilty to sending the email. However, Mr. Pibbles, they were walking, I mean, I don't believe
Okay, Ms. Underwood, I understand there's an explanation. If he wants to plead guilty, that's
Well,
fine. If he doesn't want to plead guilty,
I,
I'm gonna set
I
a
don't
trial.
suppose he can plead guilty because he wasn't taping anyone. He drove by them, so I.
All right, I just need to know guilty or not
Yeah.
guilty, and then
Well,
I'll set
he
it for a
plead
trial.
Not guilty to that part then, because he wasn't taping them.
Your Honor, if we can just get this over with, I'll plead guilty to it if we can just get this over with.
I-
I just want this over and I have no.
Mr. Pibbles, that's not how the system works. So when people say. When people say that they're not guilty, I have to have a trial to determine whether or not they are guilty. I don't accept pleas from people that say they're not guilty just to get a matter over with. So Ms. Clark, can you find us, we'll probably need an hour for a hearing on a PPO violation.
Yes, just 1 second, Judge. Tuesday, October 10th at 2:30.
That works for the people, Your Honor.
All right, so we'll set it for, Ms. Underwood, does that work?
That's fine.
So set it for October 10th at 2:30 PM. I don't know if there's room for discussion between people and defense with respect to pleading the one and dismissing the other. I'll leave that to you, but otherwise we will conduct a trial on the matter on October 10th at 2:30, and the court will issue a scheduling order.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
All right, Mr. Pibbles, Ms. Saudi, you can go ahead and log out.
Thank you, Your Honor.
Thank you, Your Honor.
All right, gentlemen at the WCC facility, you are Mr. Arrington?
Yes.
Ms. Underwood, you need a breakout session with Mr. Arrington?
Yes, thank you, Your Honor.
1 second.
Your Honor, we've called for Paulding. He's just taking some time getting down here.
Okay, thank you.
Thank you.
Mr. Malero, are you there? Mr. Malero,
Yes, Judge, I'm here.
do you need a breakout session with Mr. Paulding?
I should not, no.
All right. We are on the record in file 23-21326-FH as well as 23-21449-FH. People versus Bush v. Paulding. The file ending in 326-FH is set for pretrial hearing. The 449-FH file is set for arraignment. We are proceeding today by video conference. First, let me ask the attorneys to place their appearance on the record, beginning with Mr. Bayonetta.
Alex Bayonetta for the people.
Salvatore Malero on behalf of Bush Paulding.
Mr. Malero, with respect to the arraignment file, the file ending 449-FH, does Mr. Paulding wish to have the information read?
Your Honor, we would waive reading of the information, acknowledge its receipt, and waive any defects at the time and place of service. We'd further acknowledge receipt of the witness list. Mr. Paulding would plead not guilty and ask that the matter be set for pretrial.
All right, I will enter a not guilty plea for Mr. Paulding. We'll set this for a pretrial on September 6th at 8:15 a.m. Is there anything that we need to address in the other file?
Your Honor, I spoke with Prosecutor Arnold yesterday about these matters, and I would ask that this be set for a pretrial on the same date, adjourned, and we'll do the stip in order.
Okay. Mr. Bayonetta, anything to address from the people's side?
No, Your Honor.
All right, so we'll set it for a pretrial on the same date, September 6th at 8:15 a.m. Mr. Miller, if you would do a stip in order on that one, I would appreciate it.
I will, Your Honor. Thank you.
Okay. Thank you then. Anything else we need to address today?
No.
No, Your Honor.
All right, Mr. Paulding, you can let the officer that's with you know that you are done with court for today.
All right, thank you.
Thank you, Judge. Thank you, Mr. Paulding.
Yeah.
Well, it's kind of judge will say first. Could we have Kyle Bryant and move the judge release? Thank you.
We are on the record now in file 23-21396-FH, People versus Anthony David Arrington. We are here today for a pretrial conference in this matter. We are proceeding today by video conference. First, let me ask the attorneys to place their appearances on the record, beginning with Mr. Bayonetta.
Alex Bayonetta for the people.
Ron Underwood for Mr. Arrington this morning, Your Honor.
All right, and Ms. Underwood, where do we stand with Mr. Arrington's case today?
Your Honor, this is our first pretrial. The criminal responsibility on this matter has not come back, Your Honor. I'm not sure it's even been done. I would ask that this matter be adjourned for 2 months and we see where we are at that point.
Okay, was the criminal responsibility ordered down in district court?
It was, Your Honor. Thank you.
All right, Mr. Bayonetta, anything we need to address from the people's standpoint?
No, Your Honor.
All right, yeah, I do see an order for evaluation relative to criminal responsibility was entered by Judge Shadler in district court back in June. So 2 months is probably a reasonable amount of time, given what it takes to get those completed. So about October 4th at 8:15 a.m.
Thank you, Your Honor, and I will prepare the stipend order.
Okay, thank you, Ms. Underwood. All right, Mr. Arrington, thank you for your time. We are, you can let the officers, or the officers that are there with you, we are done with court for today.
All right, thank you.
Thank you.
Thank you.
All right, Ms. Van Duzen, we have Mr. Brian here. Do you need a breakout session with him?
I don't, Your Honor. I actually need a breakout session with you and a prosecutor.
Okay, let me see. So all right, give me a second to clear everyone out. Ms. Underwood, we do have Mr. Pappen back now, so as soon as I'm done with Mr. Bryan's case, we'll get to yours.
Thank you, Your Honor.
Okay.